Hi, this is Jen Rubin, editor-in-chief of the Contrarian. We're thrilled to have back with us Steve Vladeck, who is the great source for all things constitutional, legal, procedural, and all the rest. Happy New Year, Steve. Welcome
Happy New Year,
back.
Jen. Is it still only January?
Yeah, it's been a long decade this month, huh? Um,
Uh,
s-
this
so,
month, this week, this what you name it.
yes. So let's talk a little bit about Maduro. He is a criminal defendant as of this moment. Um, what are the prospects for prosecuting him, and what are the sorts of issues he's going to raise in his defense?
Sure. I mean, I think the first thing to say is none of this is going to happen quickly because there are some significant questions that the district court's going to have to answer. There's going to be, I think, a fair amount of maneuvering along the way. So I think the two big buckets of just straight off the bat pretrial questions are about whether he'll have any basis for challenging even the assertion of jurisdiction over him in a U.S. court based on the means by which his presence was obtained, i.e., we sent troops into Venezuela to forcibly remove him. And then the second is even if U.S. courts would otherwise have jurisdiction, is he entitled to what's known as head of state immunity? Because some, if not most, of the acts charged in the indictment relate to things he did while he was president of Venezuela. And those, there are others, but those strike me as the two biggest.
Right. And let's go to each one of this. I would suggest there's also a third, which is a proof problem that they actually have to prove that he was engaged in this behavior. And this administration is fast and loose with the facts and very quick to claim national security in producing any evidence of anything. So good luck prosecuting him
Well,
on that
but
front.
Jen, I mean, there's an important point there, which is unlike, in the court of public opinion and unlike in civil litigation, I mean, the burden is going to be on the Trump administration, right, in these cases to come up with not just evidence, but admissible evidence that would prove these charges beyond a reasonable doubt. And so, yes, I mean, I hadn't even gotten to the question of like what would actually happen at trial
Yes.
because, I'm not sure how quickly we even get there.
Right. And I think we should keep in the back of our mind that this could end in a humiliating defeat in which he is actually exonerated or the case is thrown out. But let's start with your two buckets, which are much more timely. Let's start with the means by which he got here. I think it may shock people to know that there's a pretty well established doctrine that it sort of doesn't matter if you've been kidnapped and brought to the United States. That in and of itself doesn't matter. Is that applicable here? And could there be any exception that he could find to that?
So that's the question. I mean, so the doctrine is known in nerdy law professor land as the Kerr-Frisbee doctrine because the two cases that articulated it were named shockingly Kerr and Frisbee.
Yes.
But the sort of the Kerr-Frisbee doctrine stands for the basic principle that it doesn't matter how your presence was obtained as long as you are now properly before the court. And the Supreme Court reaffirmed that as recently as 1992 in a case called the United States versus Alvarez Machine, where the DEA had actually forcibly abducted the defendant, a Mexican national, from his home in Mexico. And the Supreme Court still said, eh. Now, there's an exception that the Second Circuit, which is relevant because it's the federal appeals court in which this case will unfold, recognized in the 1970s in a case called Toscanino for circumstances in which the government's conduct along the way to securing the defendant's presence, quote, shocks the conscience, unquote. And so, in the abstract, for folks who haven't, read up on this doctrine, you might think that a military operation invading the sovereignty of a foreign nation, killing, at this point, I think we're told upwards of 80 Venezuelan nationals along the way, shocks the conscience. The case law, though, is not so, how do I say, commonsensical. So, for example, when Ahmed Gailani, who was one of the principal suspects in the embassy bombings, was prosecuted in Manhattan in the 2000s, he tried to argue that the way he had been brought to the court shocked the conscience, including torture. And the court said, nope, not so much. So, the Toscanino exception is out there, Jen, but it's very narrow. And I guess it's hard to imagine that that would be the fulcrum, right, on which this case pivots.
Right. Is there anything else about his capture or collection of evidence that was there that's going to raise any kind of Fourth Amendment power? This doctrine says you can't raise the seizure part of the Fourth Amendment against yourself, but what about anything else they collected while they were there?
Maybe. I mean, so I think the question, Jen, turns to what the government would actually want to admit from what they did over there. So, there is a case called Verdugo or Quides, which stands for the proposition that that non-citizens outside the U.S. don't have Fourth Amendment rights. But one of the things we learned in the plea call or I guess the opening arraignment on Monday was that he wasn't Mirandized right at any point after his capture, and that he wasn't aware of the Miranda warnings until the judge advised him of them. And so, if the government were to try to use any statements he made during the capture, during his transportation back in the United States, I think that would raise some questions. But Jen, a lot of the charges are about stuff that happened in the past and not
Yes.
like ongoing criminal behavior. And so I suspect that DOJ, at least savvy prosecutors, would try to avoid even provoking those questions if they could.
And speaking of actions in the past, are there any statute of limitations issues? And since it's unclear if this is ongoing or what part of it is ongoing.
Maybe. I mean, the best I can say there is maybe. I think the real issue with the sort of the time scope and time horizon of the indictment is that it overlaps with a period of time in which even the United States recognized Maduro as the legitimate head of state of Venezuela. And so that gets what to me is probably the biggest threshold question in this case,
Yes,
which is head of state immunity. Um,
right.
so everyone agrees that head of state immunity, which is a common law doctrine, it's not statutory, protects heads of state from criminal prosecution for anything they do while they are recognized by our country or whatever country is trying to prosecute them as the head of state. And I think there's pretty broad consensus that both the Obama administration and the first Trump administration recognized Maduro as the legitimate successor to Hugo Chavez. In 2013, when he became interim president, after the election in 2013, when he became president in his own right, and really, Jen, all the way to the far side of the 2018 Venezuelan elections, about which there were serious questions of integrity and legitimacy. So what that means is that there was this 6-year time period where we recognize Maduro as the legitimate head of state. And the notion that some of the offenses and some of the allegations in the indictment overlap with that time period seems like a real problem. And even under relatively settled precedent, I think is going to run into serious head of state immunity questions. What's much messier is those features of the indictment that post-date 2019, because there are lots of cases, and Noriega is a good example, where federal courts have rejected head of state immunity defenses on the ground that the relevant person claiming they were the head of state was not recognized as such by the United States government and or was not actually serving as the de jure head of state. They were just, in Noriega's case, he was just the de facto head of state on
Yeah.
the far side of a military coup. And this is where things get tricky because it's clear that neither the Trump administration or the Biden administration from that point on recognized Maduro. But, right, you still have the problem that he had been recognized. And so we don't have a case like this. We don't have a precedent where you had a criminal prosecution of someone who was the recognized head of state, and then something happened to lead to their de-recognition. And then the question is, what is the immunity? How does the immunity doctrine work in that weird hybrid situation? We just don't know because there haven't been cases like this before.
Right. And it's interesting also if the conduct began during a period that he was recognized, whether that's sort of the fruit of the poison tree, as if to take the metaphor, the vine extends during a time that he perhaps was not recognized. Did you get any sense from this administration what their answer to these things would be about
Not
immunity?
yet.
And this, of course, is coming from an administration that, understanding this is American constitutional law, but has granted vast immunity to Donald Trump himself, and for all the reasons that he stated. So I suspect that Maduro is going to be quoting John Roberts back to the court. Um, do you have any sense of what the administration is going to say in response?
I don't. I mean, that we haven't. I mean, we don't even have a formal statement from the administration of what the legal basis was for the operation, let alone what
Yes,
the right. I
yes.
mean, so these are early days. I mean, at some point, of course, the Justice Department's going to have to file a brief. That's going to have to actually make these legal arguments as best as they can be made. My best guess is that the administration will say a couple of things. First, that recognition is purely within the province of the executive and can't be second guessed by the courts. And so, certainly from 2019 onwards, there shouldn't be any head of state immunity at all. And as for the pre 2019 stuff, Jen, I'm not sure how DOJ salvages that. Without really doing violence to the doctrine. I mean, maybe the argument is that because it continued into a period in which he was no longer recognized, but I think courts are going to be wary about that. So I think it's very possible we end up with a sort of cleaving of the charges where, all of the charges, at least against Maduro, remember there are five co-defendants, but at least against Maduro, the charges that predate at least the 2018 election all get thrown out. And
Right,
he can only be prosecuted for stuff that postdates the troubled, if not illegitimate, 2018 election that kept him in power.
right, right. And then it will be, as we said, a fact problem about what facts they actually have, whether there are good facts post 2018 or not.
But also,
So
but Jen, your point about the Trump case, I think, is also really important. I mean, all of the case law we have on head of state immunity predates, July 2024, when the Supreme Court recognized a remarkably broad vision of what is effectively head of state immunity, right, in our Constitution itself. Now, there's no argument. I don't think you could plausibly argue that Article 2 of our Constitution confers immunity upon foreign leaders. But I do think that Maduro's lawyers will, as you say, right, find a lot in the Chief Justice's opinion that really is going to cause trouble. Because even if, I mean, there's one last step here, even for a period of time where he was not recognized as the head of state, right, Maduro might still argue that he's at least entitled to some kind of weaker official act immunity. Um,
interesting.
right, at which point we run into the breadth of how John Roberts defined official acts in the Trump case. So,
Yes.
I don't mean to say that any of this is open and shut, but I think that itself is the point, that this is by no means going to be the sort of slam dunk that I think the Attorney General would really wish people
Right.
would believe.
And this might be a time where the administration regrets losing all of those smart lawyers who have litigated over decades. And I don't want to diminish the value of certain people who are still there, but they may not have the A team left to litigate this and other matters. So put a pin in that. Um, Today is the fifth anniversary. It's hard to imagine it was 5 years since an attempted coup. And to everyone's amazement, Donald Trump is back in office and arguably behaving much, much worse than he was before. Where do you see, as a legal matter, the attempted coup? Is that going to be, and the cases that were prosecuted, do they kind of disappear from the statute books because of the pardon? Is there a potential, if he would do it again or other people would do it again, to use those cases in some way? In other words, is there any precedential value to the prosecutions that were undertaken?
So I think the answer is yes, but I think in two very different respects. I think as legal precedent, we do have a series of appellate decisions and one Supreme Court decision about the scope of the statutes that, were used to prosecute all these cases. So, the Supreme Court's decision in the Fisher case, for example, that narrowed the obstruction statute, a number of DC Circuit decisions about the other criminal statutes that were deployed in those cases, about the lack of entitlement of so many of those suspects and defendants to bail while they were being prosecuted. Jen, those haven't been wiped off the books,
Yeah.
even though many of those defendants were in fact pardoned. I think all of them were pardoned. So, it's not like 5, 10, 15, 20 years from now, someone who goes to look for those cases won't find them.
Yes.
But I also think there's the historical precedent. And, as much as this administration and its supporters are invested in trying to, erase some of that from the history books, the report of the January 6th committee is out there. It's not going anywhere. The sort of the floor speech that Mitch McConnell gave on the evening of January 6th, 2021, has not been expunged from the Senate record, right? And so, I don't have a lot of faith that we're going to be able to tell this story comprehensively right now. But at least the amateur historian in me is not worried about, calmer, saner minds sometime 10, 15, 20 years from now, having
Yes.
access to the relevant sources and telling the full story in a way that I think is much more consistent with how you and I have always viewed it than how the president and his supporters do.
Okay. I personally am looking forward to Mike Pence's autobiography when that ever comes out, because again, the irony of all this is that these were Republicans, as Jack Smith said. And
And indeed, and Jen, and one wonders. I mean, if obviously this is putting a lot of ifs into a sentence, but in a world in which for whatever reason there's a Democratic president in 2029 and or Democratic control of Congress and or a fracturing of the Republican Party over whether you are Trumpers or not, maybe that becomes part of the story again, the way it was,
yes,
at least in those first couple of weeks after January 6th. I mean, what's really striking to me, thinking about this 5 years on, is that, there was a period of time, and I think it ended far too quickly, where it really did feel like the tide had turned against Trump, like
yes,
senior Republicans were finally willing to bid him, good riddance, and where people understood how close we came to really, an incredibly perilous situation on January 6th. And what's so remarkable about that is not that it ended, because clearly we see that it ended, but that it existed. Right, that we had this moment where there really did seem to be national political consensus. And I think the question now, 5 years on, is are we going to be able to reach that moment again based upon, sort of what happens between now and 2029?
Smith testified behind closed doors. It was very evident how things went because he was very anxious to put it out there and then to testify again in public, and the Republicans were not. What were your major takeaways from that, aside from just how impressive, how what his demeanor was, which is exactly what you want in a prosecutor? What factually or legally struck you about that?
Um, I don't know that we learned a lot legally that people who had been paying close attention didn't already know. I think what is so useful to see is just how confident he and his team were about the strength of the criminal cases against President Trump.
Yes,
Um, and, yes, that sort of gets us back to the Supreme Court and Chief Justice Roberts, but one does wonder whether, if Smith had had another 6, 8, 10 months of runway, um, right, whether there might have been such progress in those cases before you even got to the nominating process in 2024 that history might look a little different. Um, that's,
exactly.
that was my principal takeaway, was that it was so clear that they were convinced that they had him. Um,
Yeah.
and that these were not shots in the dark. These were not, 50-50 cases. These were let's go. And the timing issues, both internally and then once you had, Judge Cannon, for example, dragging her feet and so on, were just so catastrophically important in derailing those cases.
Yeah, I think what came across to me is that by delay, the Supreme Court prevented Jack Smith from that opportunity. Had it gone forward, had they even had they come to the same Bollock's decision, that Smith would have had almost a year to kind of work his way through that and work around it in a revised indictment. Um,
Which, by the way, is what I think Justice Barrett at least had in mind. I mean, right? I mean,
yes,
we spend so much time when we talk about the Trump immunity case talking about the majority opinion. Barrett's concurrence, I think, was trying to provide a roadmap to Judge Chutkan about how to proceed on remand. It's just,
yes.
everyone ran out of time.
Yes, exactly. So where are we? I make the case very strongly and sadly that we have a very battered, almost Swiss cheese constitution at this point. The impeachment power is essentially dead letter. The Article 1 has been eviscerated by neglect of Article 1. The take care clause of Article 2 is perversely used to justify violation of international law, which he is bound to enforce under the Supremacy Clause. The courts have disabled themselves. Rather, the 14th Amendment is now kind of pockmarked. Is that a permanent damage? Do you see a world in which we kind of reassemble the quaint notion of checks and balances, of limited executive power? And how do we, if it is, how do we get from where we are now to getting back, which was even 10 years ago? We're not talking about a lifetime.
Yeah. It's a big question. I can't pretend to have a deep and profound answer. I think there are two things that strike me. So the first is that I do think that a different Congress and a different president would actually be able to build back a lot of this stuff pretty quickly. And that would take a Congress that was invested in its own institutional prerogative and a president that was willing to let Congress be so invested, much like Jimmy Carter, who, signed without
Yes.
disagreeing, without disapproval, dozens of post-Watergate statutes that were designed to rein in the powers of the executive branch. And so in the short term, Jen, I actually think we could see meaningful change happen pretty quickly depending upon the electoral outcomes, both this November and in 2028. That's the good news. The rougher news for me is that even if that happens, I think there is now, we've sort of broken the seal on the instability of the separation of powers, where there were so
Yes.
many structural relationships that had been built over decades. There was a bureaucracy of, dedicated, mostly apolitical or non-political career employees within the executive branch, right? I mean, there were these institutions that we had built up to basically keep the train rolling down the tracks. And we might be able to sort of shove the train back onto the tracks in 2029. But I'm much more worried now about the stability of those tracks, and about
Excellent.
the long-term predictability of what happens versus, how much of a historical, if not legal precedent we've now set for a future president and a future Congress to rip the tracks up again.
Absolutely. And I'll close with an equally big question, which is we have a Supreme Court that has done tremendous damage to the structure of our Constitution. They have had ethical problems, but really what they've done is twisted and deformed the constitutional system. What should be the response to that in terms of
Yeah.
either its jurisdiction, its size,
Yeah.
term limits, the ability of a new set of justices, which there will eventually be over time, to revisit these issues? What do we do about them?
Also, I think again a longer conversation, and one you and I have had in bits and pieces before. I mean, I don't know that I am speaking for anyone other than myself, but I continue to think that the real problem with our current Supreme Court is not its composition, but its complete lack of accountability.
Yes.
And that the courts, the extent to which the Supreme Court has become unaccountable is not a brand new thing. It's taken 25, 30, 35 years, right?
Yes.
With the sort of disappearance of a middle on the court. Now we're seeing it. And so to me, the way that you get the Supreme Court back is not by expanding it, which I think would really weaken it as an institution, not by taking away its power. I mean, I think we've seen over and over again over the last year why we still need courts to push back against tyrannies of the majority. I think it's reforms that will make the court more accountable to us. And so that's things like an inspector general. That's things like, Congress reasserting control over the court's docket, reasserting control over the court's budget. I mean, just the kinds of inter-branch checks and balances that, for generations define not just Congress's relationship with the executive branch, but also its relationship with the courts. And, that's not a short-term fix, it's a long-term one. But I think that's, if you want a court that is both powerful and broadly respected, which at least I do, right? I think that's got to be at least part of the conversation for how we get there.
And how would term limits fit in this, which would be make them maybe more responsive or less inclined to take these jaunts into the future since they know somebody else is going to be sitting in that chair in a set period of time?
Yeah, I'll just say I'm a skeptic on term limits for two reasons. One, I don't think they would have the stated effect of depoliticizing the appointments process. Actually, if anything, I think it's the other way around because now the Senate majority knows that if it just waits 2 years, it's getting another seat to fill. Um, but two, even to do it without a constitutional amendment, which, an amendment's never going to happen, I think for it to be constitutional as a statute, it would have to be only prospective, meaning would only apply to future justices. And so, even for those who think it's a great idea, and I'm not one of them, it's a great idea that I think wouldn't fully be in effect until the last of the current justices is off the bench, 30 years from now. It's not a reason not to do it. It's just to me a reason to prioritize other stuff first.
Right. Well, we will save for another day our debates on expanding the court on term limits. There is a healthy debate, and it's one that we frankly should have because I think the first step is a general recognition that the Supreme Court is irretrievably broken. Just ask the lower court judges and they will tell you.
Yep.
And I think the temptation to do a short-term fix in jurisdiction stripping in increasing their size is going to be great if we have not terrific, but in magnitude is going to be large if in fact a Democratic president and a Democratic Congress are in power in 2029 and beyond, given the fact that they see a catastrophe that has been left them and the need to really do some major, major reconstruction. Steve, as always, thank you. The fact that we continue to have these conversations, I find is encouraging because it means people still care about the Supreme Court and
Yep.
about the Constitution. And we are reminded again, because Maduro is in court, that the lower courts are a phenomenal break against illegality, and they have done a Herculean task of holding the line. So they will need our support and best wishes going forward. Thanks so much, Steve. We'll look forward to talking to you soon. Bye bye.
Thanks, Jen.